Okay, this is file 23-21255-FH, People versus Brian Matthew Dennis. We are here today for a hearing on a probation violation. We are proceeding today by partially by video conference, partially in person. Just going to have the attorneys place their appearance on the record, beginning with Ms. Underwood.
Your Honor, I don't believe this is Miss Brenner. This is
Mr.
is it?
Yeah, no, this is not a AG case. It's
This is a probation violation, Your Honor, and Mr. Dennis has an underlying district court matter. So we would be asking to adjourn this for probably a couple weeks, Your Honor.
okay. Why don't we set it then for November 12th at 8:15 a.m.
Thank you.
So, Mr. Dennis, your next date will be November 12th at 8:15 a.m. and you can either come in person or join by Zoom, whichever you prefer.
Tomorrow? So I can write it down.
Yeah.
Okay.
He was adjourned to when, Your Honor?
November 12th.
Thank you.
All right.
Okay, so you are all set for this court for today.
Thank you, Your Honor.
Okay, and then Rhonda, Mr. Boss is not logged in at the moment. So you're aware of that.
I'm sorry, Your Honor. I hope we can give Mr. Boss a little more time.
He failed to appear at our last hearing, so I don't know if you've heard from him, Rhonda, but if you have a number, if you could call him just to make sure, that'd be helpful.
Okay, Mr. Glazer, are you ready to proceed with Mr. Vaughey?
Yes, I am, Your Honor.
Okay, this is file 25 dash, oh, I'm sorry, we don't have a, I don't think I have a prosecutor right now, so I'm gonna have to wait. We will get started as soon as we have a prosecutor then.
Okay.
Okay, Mr. Simmons, are you there? Mr. Simmons, if you can hear me, I need you to unmute your device. Okay, can you hear me, Mr. Simmons?
Yes, sir.
All right, I don't think I have any hearings for you today. I'm just looking at the register of actions in your case, and our next date is November 19th at 8:15.
I was supposed to get the tether off today for violation of bond conditions.
Okay, I'm not aware of anything about that. I can put you back in the waiting room, and if Mr. Goldstein appears, I'll bring you back in.
Okay, thank you, sir.
I don't think I'm docket you.
I don't have
Okay, let's see, Mr. Sneed, are you here for pretty much everything, or are you covering specific cases today?
Everything, Judge.
Okay, so we can do Mr. Balky's case then. So this is file 25-22396-FH, People versus Derek Mitchell Balky. We are here today for a pretrial hearing in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
John Glazier on behalf of Mr. Balky.
All right, and sir, you're Derek Mitchell Balky?
Yes, Your Honor.
All right, and Mr. Glazier, where do we stand with Mr. Balky's case today?
Your Honor, Mr. Balky, we'd asked to adjourn the pretrial out 30 to 60 days. He's what program are you in, Mr. Balky?
I'm in Harbor Hall in Petoskey, Michigan.
Harbor Hall, okay. He got into an inpatient program. I think you only been there about a week or so, haven't you?
14 days tomorrow.
14 days. So we'd asked to adjourn it, and then once he finishes that, he's got into a drug court up in Jackson. So I just need to get with Mr. Hartung and work out what we're going to do on this.
Okay. And I'm sorry, how much time did you want to move it out?
30 to 60 days. If he gets out, he knows he's got to report up to Jackson. He knows he's got to zoom in for the next pretrial if he happens to finish the program before that.
Okay. Let's go with December 17th at 8:15.
That was 8:15.
Correct.
Make sure you zoom in on that day, Mr. Balky, and we'll try to resolve the whole thing that day.
Okay. Yeah, regardless if I'm done with the program or not, I'll make sure that I zoom in.
Okay. Yeah. If for some reason you're in the drug court up there, just make sure you zoom in.
Okay.
All right. We're all set, Your Honor.
Mr. Glazier, would you do a stipulation in order for that adjournment, please?
Yes, Your Honor.
And Mr. Sneed, was there anything we needed to address from the people's side?
There is not. Thank you, Your Honor.
Okay, thank you. Then I think we're all set. Mr. Balky, you can go ahead and log out.
All right. Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Okay, let's see, Mr. Burkett, I have Mr. Dill here. Are you ready to go with him, or do you need to speak to him?
Good morning, Your Honor. Raymond Burkett here. No, I do not need to speak with him. Thank you for the opportunity.
Okay.
Hi, good morning.
Okay, Mr. Dill, if you can hear me, I need you to turn your video on. Okay, so this is file 24-21967-FH, People versus Deontay Laquan Dill. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Isaac Sneed for the people.
Once again, good morning, Your Honor, to you and your staff. Raymond Burkett on behalf of Mr. Deal.
Okay, and I'm sorry, Mr. Sir, you are Deontay Laquan Dill?
Yes. Good morning.
Okay, thank you. And Mr. Burkett, where do we stand with Mr. Dill's case?
Well, since your ruling on the case a couple of months ago, we're waiting to see what the prosecutor's position was.
Mr. Sneed, is there an offer in this case at the moment?
Yeah, we have a misdemeanor offer with no immediate jail.
All right, Mr. Burkett, is that something you need to speak to your client about?
No, I have, Your Honor, but the problem, Your Honor, since your ruling and the district court's, well, I should do it backward. Since the district court's ruling and your ruling about the search being illegal, our position is the prosecutor doesn't have a case and they should dismiss this case.
Well, it doesn't appear that they're willing to do that at this point, so I can set it for trial.
That'll be fine, Your Honor.
I think the people would just request one more pretrial. This will be resolved prior to a trial being held, so one way or the other.
I wouldn't disagree with that, Your Honor.
Okay, my issue with that is this case is getting really old. I want it to move forward, so I will set one last pretrial, and it will be set for trial if it's not resolved at the next pretrial.
Understood.
Yes, Your Honor. I
Let's go with November 12th at 8:15.
just one brief second. Your Honor, that will work for the defense.
I'm sorry, did you say that will work?
Yes, Your Honor, it will.
Okay. Okay, thank you. So November 12th at 8:15, and you'll log in using all the same Zoom information that you used today.
Yes, Your Honor.
Okay, I think we're all set then. Mr. Dill, you can go ahead and log out.
Thank you. Have a good day.
Should be, okay. Okay, thank you then, Mr. Burkett. I think we're all set.
Appreciate it very much, Your Honor.
All right, Mr. Murphy, are you ready to proceed with Mr. Morris?
Yes, Your Honor.
Okay, so this is file 25-22334-FH. People versus Robert Scott Morris Sr. We are here today for a pretrial conference in this case. And we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Sneed?
Isaac Sneed for the people.
Matthew Murphy, appearing by Mr. Morris.
All right, and Mr. Murphy, where do we stand with Mr. Morris's case today?
Your Honor, first of all, I made aware yesterday of motion and affidavit, order to show cause for Mr. Morris in regards to testing positive on, I believe it was 10/13. His admitted last use to Mr. Coast was on 10/10. From my understanding, I had emailed Mr. Baynetto, who I had down as the attorney or the prosecutor on record in this case. I believe he is, he just isn't in the office right now. He hadn't responded. He texted me saying it is his case, but he hasn't viewed the email. I wasn't sure. From my understanding, there was an offer of use for Mr. Morris to plead to use on the underlying charge with agreement for no upfront jail. I think Mr. Morris wanted to plead guilty to that if that was still available. Again, we just wanted to make sure, given the allegation of the use of cocaine on 1010 or testing positive. He also wanted to plead guilty to that as well today, Your Honor. Again, if that's still available, if Mr. Sneed can, enlighten us, I'm not sure if it's not available, if the prosecutor needs more time. Again, he wants to plead guilty to that allegation and ask for another pretrial.
If the offer that I have from July is to count one as charged and dismiss the habitual offender supplement, Mr. Murphy, I don't see any notes regarding an offer of use.
Then, Your Honor, I guess we'd ask for another pretrial. I don't, my understanding was that was what I was talking to Mr. Baynetto about. And obviously there is no agreement right now. I don't think the case is too old that another pretrial would be inappropriate to hammer that out. But again, in regards to the allegation of the bond violation, we would like to address that today and plead guilty.
He has a show cause for a bond violation on 1013. I don't have anything in file on that.
Judge, it should be in the file. I have a copy of it. I could run it in there for you.
I would appreciate that. I don't have anything.
I'll be right in.
I've got a letter. I don't have anything about a show cause.
Text message.
Okay, and Mr. Murphy, you said he wanted to plead to this today?
Yes, Your Honor. We would ask for a pretrial to be scheduled. We'd do a stip in order, I guess, to adjourn the underlying charge, and he wants to plead guilty to that allegation. That's again my paperwork I have says defendant tested positive for cocaine from a drug screen collected on 10/13/25 by pretrial services coordinator Coast. Defendant stated his last use of cocaine was on 10/10/25.
All right, Mr. Morris, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
And you are Robert Scott Morris Sr.?
Yes, sir.
Mr. Morris, you understand that the maximum penalty for contempt of court is up to 93 days in jail or up to $7,500 in fines?
Yes, sir.
And this motion and affidavit for show cause alleges that you tested positive for cocaine from a drug screen collected on October 13, 2025 by pretrial services coordinator Coast, and that you stated at that time that you last used on October 10, 2025. Do you understand that that's the allegation against you?
Yes, sir.
Are you satisfied with Mr. Murphy and the advice that he's given?
Yes, sir.
Do you understand that you have a right to contest the contempt of court charge and have a trial on it?
Yes, sir.
Do you understand that throughout that trial, you would be presumed innocent until your guilt is proven beyond a reasonable doubt?
Yes, sir.
You would have the right to have all of the witnesses against you appear at your trial. You or your lawyer could ask those witnesses questions. And you also have the right to have me order any witnesses you have for your defense to appear at your trial. You understand that?
Yes, sir.
You are not required to testify at your trial, and nobody can say anything about you not testifying or hold that against you anyway. Do you understand that? On the other hand, you'd have the right to testify if you wanted to testify. Do you understand that too? How do you plead to the charge that you committed contempt of court by testing positive for cocaine?
Guilty, sir.
Do you understand that by pleading guilty, you're giving up your right to a trial and your right to have your lawyer's assistance at that trial, as I've already explained?
Yes, sir.
Has anything been promised to you in order to get you to plead guilty?
No, sir.
Have you been threatened in any way in order to get you to plead
No,
guilty?
sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
Yes, sir.
Is it your own choice to plead guilty?
Yes, sir.
So you've been on bond conditions that prohibit the use of any controlled substance, is that correct?
Yes, sir.
And on October 13th, did you test positive for cocaine?
Yes, sir.
And had you in fact used cocaine in the days before that test?
Yes, sir.
I will accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Morris has had full knowledge of his rights and he has had competent counsel.
I've eliminated a key part of my life.
I'm sorry,
I said I have eliminated a few people in my life.
I'm having trouble.
I said I have eliminated a few people out of my life because of this.
All right. Mr. Murphy, is there anything you wish to say before the court passes sentence?
Your Honor, I think, given the underlying charge being drug related as well, I'd ask the court to consider a fine in this matter. I think, you know, Mr. Morris might need some testing and maybe some counseling, maybe attendance at, you know, some NA meetings, things like that, I think are appropriate in this situation to be ordered. And again, I had to have a talk with Mr. Bayonetto about the underlying charge at this point, but I think that's going to result, you know, the next pretrial will probably be a plea, and then Mr. Morris will be addressing any issue he has. We'll probably end up, you know, having some substance abuse evaluation done and seeing what services will be provided to him. But at this point, again, I'd ask the court not do any incarceration, to do a fine, and again, try to monitor and see if any counseling or anything would be appropriate.
Mr. Morris, is there anything you'd like to say on your own behalf before the court passes sentence?
No, sir.
Yes, my concern is we just went through some contempt issues. Court sentenced Mr. Morris to 30 days in jail with 23 days credit back on October 1st. And so that doesn't leave a lot of time between when you would have gotten out and when you tested positive. So, you know, you turn around and immediately started using again. And I don't know what I'm supposed to do with that under those circumstances. It's, you know, the idea of the initial incarceration was hopefully you would learn a lesson and stop the behavior. And that doesn't appear to have been the case. And so from my perspective, I have to ask, does message from my side need to be sent louder because you didn't hear it the first time?
I understand. That's why I've eliminated a few people out of my life.
The other issue I have is that, you know, we've been testing you here at a reduced rate because there was a suggestion that you couldn't afford the testing, but somehow you're finding cocaine. So, you know, you might have money for testing if you didn't use the cocaine. So what I'm going to do at the moment is I'm going to hold off on the sentencing. I'm going to adjourn that to whatever date we set the next pretrial for. I'm going to modify your bond conditions so that you participate in, is a requirement of your bond that you participate in a substance use counseling or 12-step program to do 90 meetings in 90 days, so one every day, and provide evidence to Mr. Coast that you are doing such a program, continue with your testing. I'm going to direct Mr. Coast that if there's another positive test to immediately go to a warrant and not a show cause, because I can't, I'll give you one last chance, but I can't have you out there using. If you're going to be out there using, I've got to remove you from the street and try to stop you from using that way. So that's where we are. And I will adjourn the pretrial to October 29th at 8:15.
Yes, Your Honor.
If we're not resolved at that point, I'll be setting it for trial because we're at about 90 days right now. And
I understand, Your Honor. Thank you.
It's time to resolve or set it for trial. So, Mr. Murphy, would you do the stipulation in order to adjourn pretrial?
We will, Your Honor.
I think we're all set for today.
Thank you, Your Honor.
Hey, Robert, go ahead and have a seat out in the hall so we can discuss the counseling and also the NAAA.
Yes, sir.
May I have that date again, Judge?
That was November,
October 29th.
I'm sorry, October 29th.
Thank you.
Okay, and then Mr. Murphy, did you have Daniel Owen?
I do, Your Honor. Is he zoomed in?
Zoomed in. Do you need to talk to him?
I do, Your Honor. Would you give me a few minutes just to find a spot to?
Okay.
I apologize.
And Mr. Malero, I have Jennifer Ellis logged in. Is she formerly known as Jennifer Berger?
She is, Judge, and I would need to talk to her.
Okay. Mr. Owen, if you give me a moment, I'm going to put you in a breakout session with your attorney, Mr. Murphy.
All right, thank you.
Ms. Ellis, if you're there, I need you to unmute your device.
Is it unmute? Oh, okay, there we go. There we go.
Okay. I'm going to put you in a breakout session with Mr. Malero. I just need to make sure you're not actually driving right now.
Nope, I'm just parked in Meyer parking lot.
Okay.
Thank you, Judge.
Okay, I have a device logged in that is just labeled iPhone. Can you tell me your name, please?
Jason Lindsay. I'm sorry, sir. I got kicked out and then had to relog back in.
Oh, okay. 1 second. Okay, Mr. Lindsay, your attorney's working with another client right now, so I'm going to put you back in the waiting room, and as soon as he's done with that one, I'll bring you back in.
Okay, sir. Thank you.
Okay, I have a device here labeled M. Lynn. Can you tell me your name?
Monica Schultz.
Okay. All right, Ms. Schultz, your attorney is working with another client, and I'm going to put you back in the waiting room, and I'll bring you back in when he's ready for your case.
Okay, thank you.
Okay, and Mr. Dagger Margosian, I have Ms. Nicholas here. You're going to need to speak to her.
No, Your Honor, thank you.
Okay, Ms. Nicholas, if you're there, I sent you a request to turn the video on. Okay, and all right, so this is file 25-22170-FH People versus Brenda Lee Nicholas. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearance on the record?
Isaac Sneed for the people.
Your Honor, Michael Dagger Margosian for Miss Nicholas.
Okay, and Mr. Dagger Margosian, where do we stand with Ms. Nicholas's case today?
Your Honor, if the court would recall, last pretrial, I had asked for we didn't have the preliminary exam transcripts. Mr. Daly did the exam. Subsequently, our office has substituted in on this case. I don't have the exam transcript. I think we were looking into it, but I haven't had any word, and we still don't have it. So I can't really move forward without that.
Okay, give me a second. I don't have the file. Let me see what the computer system says about that. My memory is right. When I looked back through the file, I couldn't find an order for the transcript, and so I think I signed an order for it, but let me make sure. Okay, I haven't seen anything. I still don't see anything about the transcript being ordered. I don't know how that's possible. So
Your Honor,
why don't I'm sorry.
I was just gonna say, our office received a signed order of the acknowledgement of the transcript, prelim transcript from Judge Morgan's court reporter, but that's all we have.
Okay. All right. Do you know when that is dated?
It was entered into our system on 9/30. Let me see the actual order. In around that time. The exam date of March 3rd. The order was signed, it looks like 9/19.
So let's set the pretrial out then to December 17th. And you should have the transcript by that time, I would think. Okay, then, Mr. Agamragosian, would you be willing to do a stipulation in order for that adjournment?
Yes, Your Honor.
Okay, so Ms. Nicholas, your next date will be December 10th at 8:15 a.m.
December 10th?
Judge, did you say December 10th or 17th?
Oh, I'm sorry, I said 17th the first time. That's what I meant to say. December 17th, Ms. Nicholas, I
Okay.
apologize.
Okay, thank you.
Okay, you can go ahead and log out.
Okay.
All right, Mr. Murphy, you ready to proceed with Mr. Owen?
Yes, Your Honor.
Okay, this is file 25-22208-FH. People versus Daniel Jason Owen. We are here today for a pretrial conference in this case. We are proceeding today by video conference. First, let me have the attorneys place their appearance on the record.
Isaac Sneed for the people.
Matthew Murphy appearing back with Mr. Owen.
And sir, you are Daniel Jason Owen?
Yes, Your Honor.
Okay, Mr. Murphy, where do we stand, Mr. Owen's case today?
Your Honor, we had, first of all, I want to apologize to the court. At the last pretrial in this matter, a trial was scheduled. I had another attorney covering for me. The trial was set for later this month, and again, before this trial was set, I already had two trials scheduled: People versus Powers and People versus Berry. Berry being a murder case and Powers being a CSD first case, scheduled for basically 3 weeks of trial. Before this one was already scheduled, and this one was scheduled directly before those. I expressed to Mr. Sneed my concern with being adequately prepared for all of these trials coming up, and he agreed that he'll be okay with a stipulation in order that wouldn't detriment his case, nor would it detriment my case. This case, again, is fairly serious and involves almost 400 pages of a police report plus other discovery to review as well, and be prepared for trial if it goes to that level. Mr. Owen also had suffered an accident at the jail. He broke his hip. He is currently at Linwood Manor undergoing recovery. Because of that, I believe that he's scheduled another doctor's appointment on November 11th or 10th, I believe, if I'm not mistaken. Possibly more surgery after that on his shoulder as well. Right now, he's barely able to walk very much. Given all those factors, Your Honor, we would obviously, the defense's stance is that there's no detriment to adjournment of that trial. And I believe that was, I'm not sure, I didn't receive the order back, but we would again place on the record that we would ask for that to be adjourned. Now, again, we're asking for another pretrial to be set. With Mr. Owen being where he's at, it's been difficult for me for whatever reason. The phone calls to him, his phone's malfunction at his room there. When I call the front desk, they just forward it to his room, and he doesn't seem to get my message. Again, there's no ability to leave a message. There's no record of me calling. So it's been a prolonged bit of phone tag this past month. So there's also an issue of communicating with my client about a resolution outside of the ultimate trial, Your Honor. So we're asking again, if Mr. Sneed would agree that another pretrial would be appropriate, not setting another trial right now. Readdressing the case with Mr. Sneed after, again, I have an appointment, definitive appointment with my client tomorrow at 2 p.m. And I believe there'll be traction in the case, so no necessity to set a trial and clog the court's docket. Again, I do apologize for taking up that time of the court's docket, understanding there are other trials that may have not been able to be set because of that. So I do apologize, Your Honor.
All right, Mr. Sneed, anything from the people's side?
I have no objection to the adjournment, Your Honor.
You're meeting with Mr. Owen this week?
Tomorrow, Your Honor, at 2 o'clock over the phone.
I did get a stipulation, I'm sorry, I did get a stipulation to vacate the trial dates, and I did sign that, so. I'll do one more pre-trial, but this is a pretty old case, found over for the second time back in May, so it needs to either be resolved, or I'm going to set it for trial again at the next pre-trial. So I will adjourn this to October 29th at 8:15.
Thank you, Your Honor.
And again, I will, at that time, I'll set it for trial because it needs to be moving on a path toward completion.
Yes, Your Honor, and my office prepared a stipulation in order to set a pretrial on, you said October 29th?
Correct.
2015. Thank you, Your Honor.
Okay, so Mr. Owen, your next date's October 29th at 8:15 a.m. and you can log in using all the same Zoom information you need.
Okay, thank you, Your Honor.
Okay, so you're all set. You can go ahead and log out.
Thank you.
Thank you, Mr. Owen. Talk to you tomorrow.
All right,
Thank
sounds
you,
good.
Yeah, Monica Schultz is on Zoom.
I'm sorry, I'll kind of yeah, he was here when I came here. I saw him.
Yeah. And he took off or something. Good morning, Mr. Goldstein. I don't think I have you on our docket for anything today. I do have Mr. Simmons is logged in, but I don't have that on the docket.
Your Honor, I do agree, but Mr. Simmons believes, although my notes don't reflect it either, that when we had our bond violation hearing the other day, that you set a review for today. Although I don't have that in my notes, and it's not on the docket, but he believes that's what you said.
Do you happen to have his case number handy?
No, I don't, Your Honor. I don't have the file because it wasn't on my list and it's not on your docket.
I have a file number. Good. Oh, wait. Is this Isaiah Simmons?
Isaiah. Yeah.
Correct.
I have a file number of 2522121FH.
Yeah, the date that I wrote down, Your Honor, was November the 12th.
Yeah, I don't show anything in our register of actions about that. So I'll bring him in and let him know. I don't,
Your Honor, I do, before you do, I know he does want me to address the court on asking you. We asked you at the last hearing to remove the tether.
I'm sorry, I'm not in a position to do anything on the record with Mr. Simmons today, Mr. Goldstein.
That's fine, Your Honor. If you'll explain that to him, that's fine, because he's the one that thinks it's on.
Okay.
So.
Thank you. All right, Mr. Simmons, if you can hear me, I need you to unmute your device just so I can be sure that you can hear me.
Yes, sir.
All right, so Mr. Simmons, I don't have you on our docket for today. So I'm not in a position to hear anything or make any decisions about your case. I do have Mr. Goldstein here who indicated that you're of the belief that it was set for a review hearing on the issue of your tether, but I don't see any record of that in the court notes. And it's not on our docket today, so we're not going to be able to do anything with your case today.
Well, I can't afford the tether. That's the whole thing, Your Honor. I've been dropping 3 times a week. That's $60. I had to pay transportation $20. That's $80. I can't afford it, Your Honor. I can't even go to work because of the curfew that's on the tether.
Sir, your case is not on the docket, and I'm not in a position to hear this or make any decisions about it. If you want to have this issue addressed, you can talk to Mr. Goldstein and we can set it for a hearing, but it's not set for hearing today.
All right, can I talk to my lawyer, please?
Mr. Goldstein, I can put you in a
You
breakout
can
session.
call me because he just said he's not going to hear anything today. So just call me.
Well, it don't make no sense, David. How what I'm supposed to do, man? I can't afford it. I gotta pay today.
Call me, Isaiah.
All right.
Until you cross that finish line. Proverbs 24:10 says, if you faint the day of adversity, you're
Okay, Ms. Schultz, I'm going to put you in a breakout session with Mr. Murphy if you'll give me just a moment.
Thank you.
This is file 24-22060-FH, People of State of Michigan versus Jennifer Marie Berger. We are here today for a final pretrial in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Isaac Sneed for the people.
Salvatore Malero on behalf of Jennifer Berger.
Okay, so we have a trial set to begin October 28th. Are we prepared to proceed at that time?
Your Honor, I believe we have reached a plea agreement. And if the court permits, I'd like to read that into the record.
Okay, I don't believe, unless you have a advice of rights form, Mr. Malero.
I do not.
Okay, I can't take a plea without having an advice of rights form.
Okay.
Ms. Ellis, are you able to come to the courthouse today?
Yes, yes, I can.
Okay, if you want to drive to the courthouse right now, we can have you sign that form and we can get it taken care of this morning.
Just go right to your courtroom.
Yep, come right up to the courtroom.
Okay, I'll be right there.
Okay.
Thank you. So here.
Okay, and you'll call for Bradley. And Mr. Miller, this time we'll call for Mr. Rohrback.
Okay.
And what else? Oh, Jason Lindsay is logged in. You need to speak to him.
You talking to me, Your Honor?
Yeah, Jason Lindsay.
Thank you.
I don't have him on my schedule. Look, I don't think I represent him. I might though.
Oh, I'm sorry. It looks like he's just a probation violation.
Yeah, it looks like it's Rhonda.
Okay. Okay. Let's see, you had Mr. Gerhardt also. He's not, or I'm sorry, he's a violation of probation. So,
Oh, I hate it when they violate.
oh, no, Mr. Gerhardt, I guess, is just a pretrial.
Oh, okay. Even better.
He's not logged in. Have you had any communication with him?
I have not, Your Honor.
Okay.
And Judge, we just obtained a bench warrant for Mr. Gearhart for not drug testing. He's missed 3 consecutive tests.
Okay. So this is file 25-22268-FH, People of State of Michigan versus Dustin Austin Gerhardt. We are here today for a pretrial conference. We are proceeding today by video conference. The courtroom is also open to the public. First, can I have the attorneys place their appearance on the record?
Isaac Sneed for the people.
Salvatore Malero on behalf of Dustin Gerhardt.
Okay, and we do have a bench warrant was issued on the 13th for a failure to test. He had previously had a bench warrant issued on October 3rd for testing positive, so there's 2 outstanding warrants. Mr. Gerhardt also has a prior failure to appear. In this case, he had failed to appear at arraignment. And he has failed to appear here this morning. He's not logged into the Zoom session. He is not present here in the courtroom. So the court can issue a bench warrant for the failure to appear as well. And they'll set bond on that bench warrant in the amount of $50,000.
All right, thank you, Your Honor.
Okay. I think we have Mr. Rohrbach here. Mr. Malero, are you going to need to speak to him?
Well, last I was told, Judge, he was hiring an attorney. He has not done so.
Oh, is that, I forgot that's what that was.
So yeah, I guess I'll have to talk to him.
Okay. Can you call the jail, let them know that the jail room for video is off and it's muted? as soon as we get that device with its video turned on, we can do that.
All right, thank you. Bye.
Your Honor, did you issue a warrant on Trevor Boss?
Not yet. I'm waiting for Rhonda to get logged back in here. I think she went over to Judge Anselm's court.
Okay, thank you.
Okay, Mr. Rohrbach, I'm going to send you a request to unmute, and I'm going to put you in a breakout session with Mr. Malero.
Okay. Yes, I got it. Okay, yep.
Thank you, Judge.
This is file 25-22361-FH, People of the State of Michigan versus Monica Lynn Schultz. We are here today for a pretrial conference in that case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record?
Isaac Sneed for the people.
Matthew Murphy, appearing by Ms. Schultz.
And Miss, you are Monica Lynn Schultz.
Yes.
All right, Mr. Murphy, where do we stand with Ms. Schultz's case today?
Your Honor, I was communicating with Ms. McClure in regards to this matter, and she's preparing the plea form. The plea offer would be for Ms. Schultz to plead to count 1, larceny in a building, dismissal of count 2, and as well as there's a misdemeanor filed down in district court that'll be dismissed as well in regards to this case. Ms. Schultz would be entering into recovery court, and it would be dismissal after completion of recovery court, set aside conviction. Now, I had thought that I had her screened. I think that may have not have happened, but I do believe she qualifies, and I think I expressed in my notes that from my understanding she would qualify. But obviously, I think she'd go through the screening process. If there was any issue with her not qualifying for recovery court, I guess would we address at sentencing the issue or address it with the court. But it is our intention to again enter a plea of guilty to larceny from a building, count 1, dismissal of count 2, and again entrance into recovery court. And dismissal, setting aside convictions after completion.
Okay, I don't have a signed advice of rights form, Mr. Murphy. Do you have that?
I apologize, Your Honor, I do not. Would Your Honor be willing to accept it before the time of sentencing?
I have to do it before I take the plea.
Would Your Honor be willing to show Ms. Schultz the form and then I can sign on her behalf?
Ms. Schultz, are you able to come down to the courthouse right now?
Yeah.
Okay, so we'll
Yeah, I
pass
can.
this case. If you'll come down to the courthouse, come into the courtroom, I'll give you that form and you can look it over and then sign it if you're comfortable with it.
Okay, thank you.
Thank you, Your
I can do
Honor.
that. Do I just close out?
Yeah, you can leave the meeting or end whatever it's asking you to do.
Okay, thank you.
Okay, so Joe, can you bring this to?
I'm ready to inspire you.
Okay, Mr. Murphy, you ready on Mr. Spike?
Yes, Your Honor.
All right, this is file 25-22288-FH People versus Benjamin Paul Spike. We are here today for a pretrial conference in this case, and we're proceeding today by video conference. First, can you have the attorneys place their appearance on the record?
Isaac Sneed for the people.
Matthew Murphy, appearing behalf of Mr. Spike.
All right, and today's date set for a final pretrial conference in this case. I would note Mr. Spike has not logged into the Zoom session. He's not present here in the courtroom. Mr. Murphy, do you know where Mr. Spike is today?
No, Your Honor, I apologize. I saw him this morning when I arrived at the courthouse a little after 8 a.m. I spoke with him down in the district court hallway. It appeared as though he was heading down towards probation to the bathroom. I spoke with him about the case. He hadn't informed me of any change of his position or anything. But after not seeing him here in the courtroom after some time, I checked. I think he may have an outstanding warrant from district court on a previous or a misdemeanor case from a week or a couple of weeks ago or so. I'm not exactly sure on the date, but I thought I saw that. So I thought maybe he was taken into custody downstairs and double checked, and he's not downstairs in custody either. So I don't know where he is, Your Honor, at this point. I apologize.
Okay, Mr. Sneed, anything you need to address from the people's side?
We would defer to the court's discretion regarding a bench warrant. Thank you.
Okay, so we had a final pretrial set for January 7th and a trial date set for January 15th. I think what I will do is, this appears to be Mr. Spike's first failure to appear. And so what I'll do is wait the 48-hour grace period, and if we haven't heard anything from Mr. Spike at that time, the court will issue a warrant. I will leave the final pretrial trial date on for now.
Thank you, Your Honor.
Oh, yeah, if I do issue that bench warrant, the bond will be set at $50,000.
Yes, Your Honor. Thank you.
Okay, and Mr. Murphy, if you want to approach, I've got an advice rights form from Ms. Schultz when she gets here.
Thank you, Your Honor.
Oh, I'm sorry, it looks like we've also got a plea if you want that too.
Thank you. I'm just going to ask.
Okay. All right, and Ms. Ellis, do you want to come forward, please? Mr. Malero, I think we're ready to begin with Ms. Okay, so Mr. Malero, I think we're ready then. If you want to go ahead and state the terms of the plea agreement for the record.
Your Honor, I think we emailed the written plea offer to you. If you could have her review it and sign it, that'd be great. And then I think we can proceed.
I do have that, so the bailiff's going to hand you a copy of the written plea agreement, so take whatever time you need to read that over. And if and when you are comfortable, go ahead and sign. Okay, I do have that now, and it's been signed by Ms. Ellis.
All right, Judge, I believe the plea agreement is that Miss Ellis will plead to count 4 of illegal use of a financial transaction device. There will be restitution. I believe the restitution is $3,126.01. That's part of the plea offer. And as our plea agreement.
Okay, Mr. Murphy, is that a complete and accurate statement of the plea agreement?
It is, just to be complete, the people will dismiss the remaining charges sentencing.
Oh, yep, sorry. I kind of figured that goes without saying.
All right, let's see. Ms. Ellis, would you raise your hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes.
You are Jennifer Marie Ellis?
Correct.
And were you formerly known as Jennifer Marie Berger?
Yes.
Okay. Did you hear the statement of your attorney and the prosecuting attorney regarding the plea agreement?
Yes, I did.
Is it your intention to plead guilty today to count 4 illegal sale or use of a financial transaction device?
Yes.
You understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $5,000 fine?
I do.
Are you satisfied with Mr. Malero and the advice that he's given you?
Yes.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
Mr. Malero?
That is correct, Judge.
Is that also your understanding, Ms. Ellis?
Yes.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. You understand, Ms. Ellis, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
I do.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right. If you are not a citizen of the United States of America, conviction of crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization.
Yes.
Do you understand all of those rights?
I do.
Do you understand that you're giving those rights up?
Yes, I do.
How do you wish to plead to the charge that on or about July 12th, 2024, in the city of Adrian, County of Lenawee, State of Michigan, you did commit the offense of illegal sale or use of a financial transaction device?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No.
Do you understand that if I accept your plea, you're giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea?
I do.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Ms. Ellis to plead guilty to that?
No, Your Honor.
No, Judge.
Ms. Ellis, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
I do.
Is it your own choice to plead guilty today?
It is.
Mr. Malero, would you like to establish a factual basis?
Sure, Judge. Ms. Berger, is it true that on or about July 12th of 2024 in the city of Adrian, County of Lenawee, State of Michigan, that you did obtain I think it was a debit card from I think her name was Ada Windish?
Yes.
And you used that debit card to, I think it was withdraw some funds on various times from her bank account?
Yes.
and you did not have her express permission to do so. Is that correct?
Correct.
And the amount that was established was $3,126.01. Would you agree with that
Correct.
amount?
Agree.
And to be clear, you didn't have her permission to do this.
Correct.
Is the court and the state satisfied?
People are satisfied.
Okay. Let's see, has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor. Thank you.
Mr. Valero?
I'm of the opinion the court has, yes.
Okay, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Ellis has had full knowledge of her rights. She's had competent counsel. Court has not made any agreement regarding the possibility of a plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation interview and set sentencing for November 14th at 8:15 a.m.
Did you say November 14th, Judge?
Correct.
All right, thank you.
Ms. L, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview.
Okay.
Do that interview. Please be truthful about this offense and about your background.
Okay.
And if you will step across the hall to the probation department, they'll have, I think, a packet of information to give you and some information about what happens next.
Okay. Right now?
You're all set, yeah.
Okay, thank you.
Thank you, Your Honor.
Thank you, Mr. Valero. Okay, Ms. Underwood, have you had any communication with Mr. Boss?
I have not, Your Honor. Have no knowledge as to his whereabouts. I have tried to communicate with him.
All right, so this is file 25-22189-FH, People of the State of Michigan versus Trevor John Boss. We are here today for a pretrial conference in this case. We are proceeding today by video conference. Courtroom is also open to the public. First, I have the attorneys place their appearance on the record.
Good morning, Your Honor. Sarah Brenner, Assistant Attorney General for the People.
Rhonda Underwood for Mr. Boss this morning, Your Honor.
And the record should reflect that this matter was set for hearing this morning at 8:15 a.m. It is now 9:36 a.m. Mr. Boss is not logged into the Zoom session and he is not present here in the courtroom. Ms. Underwood, is there anything you'd like to state for the record with respect to Mr. Boss?
I have no knowledge as to his whereabouts, Your Honor.
Ms. Brenner, anything from the people side?
Yes, Your Honor. He failed to appear at our last hearing on September 3rd, but I gave him a break that time because he was still paying his child support. I was hoping it was just an oversight. His child support payments have stopped. He did not pay. He hasn't paid since August, and he's failed to appear today. So I'd be requesting a bench warrant this time.
Okay, Mr. Boss did fail to appear back on September 3rd, 2025. The court did not do anything at that point, but set it for today's hearing, and he's not appeared here today. So it's a second failure to appear in this case. Based on that, I am going to issue a bench warrant and set bond on that bench warrant. Ms. Brenner, what is the outstanding balance?
$13,207 even.
So I'll set bond at $13,207.
Thank you.
Is that cash or surety, Judge? Is that cash only?
That's cash only. Yeah.
Thank you, Your Honor. And I'll prepare that bench warrant.
Okay. Thank you very much.
Thank you. Have a good day.
Thank you too. Okay, Ms. Underwood, Jason Lindsay is here. Do you need to talk to him?
Yes, Your Honor.
Hello?
Okay, Mr. Lindsay, I'm going to put you in a breakout session with Ms. Underwood if you'll give me just a moment.
Okay.
Okay, Mr. Miller, we can call Mr. Rohrbach's case.
Okay,
This is file 25-22356-FH, 25-22357-FH, and 25-22358-FH. People versus Bradley Dale Rohrbach. We are here today for pretrial conferences in each of those cases, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonet?
Alex Bayonet for the people.
Salvatore Malero on behalf of Bradley Rohrbach.
Okay, and Mr. Malero, where do we stand with Mr. Rohrbach's cases today?
You're not going to ask to adjourn this matter maybe 2 weeks if the court would permit. The lawyer, Mr. Rohrbach, intended to hire, I think he was informed there may be a conflict. So he's looking into hiring a different attorney. I think he would need that time for his family to make arrangements to pay the retainer. That's the basis for my request.
Okay, Mr. Bayonet, is there anything we need to address from the people's side?
No, Your Honor.
All right, so I will adjourn this to 2 weeks, would be October 29th.
Thank you, Your Honor. Thank you. Thank you, Ms. Malero.
Yep.
October 29th at 8:15 a.m. Mr. Rohrbach, you can let him know that you're done with court for today.
I appreciate it, everything. Thank you, guys.
Judge, I'll do the step in order.
Thank you very much, Mr. Miller.
Yep, thank you.
Okay, you call for Kareem.
Could we have Kareem have me room with judge, please? Thank you.
Okay, we can do Jason. This is file 24-21749-FH, People versus Jason Floyd Lindsay. We are here today for a probation violation. We are proceeding today by video conference. First, can I have Ms. Underwood place your appearance on the record?
Rhonda Underwood for Mr. Lindsay this morning, Your Honor. Thank you.
Okay, and where do we stand with Mr. Lindsay's situation today?
Mr. Lindsay has an outstanding district court matter that is felony that is still in district court, which is the genesis of this violation of probation. He has a hearing on that tomorrow, and then I believe he has another hearing on the 3rd of November. Your Honor, could we have a date after November 3rd?
Okay, we can do November 5th at 8:15.
Thank you, Your Honor.
November 5th at 8:15 a.m. will be your next date. On this one, Mr. Lindsay, you can log in using all the same Zoom information you used today.
Okay, sir. Thank you.
Okay, you're all set then.
And I believe that concludes my docket with you this morning, Your Honor. Unless you have anything else.
Give me just 1 second. Oh, we already did Brian Dennis?
We did.
Okay. Yep, we're all set then.
Thank you.
Mr. Malero, will you need to speak to Mr. Henry?
Yeah, Judge, I will.
Okay. If there is someone in jail Zoom 2, I need you to turn the video on. I've sent you a request to do that. Okay, and then I'm going to send you a request to unmute the device so we can hear you. And you are Mr. Henry?
Yes, Your Honor.
Okay, Mr. Henry, I'm going to put you in a breakout session with Mr. Malero.
Okay.
Okay, this is file 25-22326 FH, People of the State of Michigan versus Kareem Jamal Muhammad Henry. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayoneto.
Alex Bayoneto for the people.
Salvatore Malero on behalf of Kareem Henry.
Okay, and Mr. Malero, where do we stand with Mr. Henry's case today?
Your Honor, at this time, we'd like to set the matter for jury trial.
And how many days do you think you'll need for a trial?
Probably two days.
I would agree with 2, Your Honor.
Okay. Ms. Clark, could we have a 2-day jury trial date, please?
Yes, Tuesday, January 20th at 9 and Wednesday, January 21st at 10:30.
Could you say those dates again, please?
January 20th at 9 a.m., January 21st at 10:30.
Works for the people.
That works.
Okay, so let's do a final pretrial then on let's go with January 14th at 8:15. And the court will issue a scheduling order with those dates. Is there anything else that we need to address with the case today?
Not from the people, Your Honor.
Okay, Mr. Henry, you can let the officer with you know that you're done with court for today then.
Okay, thank you, Your Honor.
Thank you, Judge.
Thank you, Judge.
Ms. Schultz? She is not coming.
Murphy's taking care of something, and Judge Anselm's and Mrs. Schultz is still down there.
Okay, the gentleman that just joined the Zoom session, can you tell me your name?
Isaac Quaylar.
Give me 1 second, Mr. Quaylar. I don't think I have you on my docket today. Let me see if I can look you up.
Okay. Yeah, I called them 2 days ago. They said I had a court date October 15th, November 3rd, and I think the 17th of November.
Judge, I believe his hearing's down in front of the court, a referee hearing.
Okay. All right, 1 second. Do you know, Ms. Clark, which referee he is with?
I do not.
Mr. Quaylar, do you happen to know your case number?
No, sir, I do not.
Okay, so it looks like your hearing is with the friend of the court, not with us. So if you have any paperwork there, you'll need to check that and make sure you understand which referee you need to log in with. If you don't have your paperwork, you can call the friend of the court and they should be able to help you because I'm not able to find that from my computer system.
Okay, sir.
So you're all set. You can go ahead and leave the meeting.
Yeah, so I think it's. She just needed what young askers right now.
Okay, we are back on the record in file 25-22361-FH People versus Monica Lynn Schultz. And they do now have signed advice of rights form from Ms. Schultz. So Mr. Murphy, if you would like to place the terms of your plea agreement on the record, then I'll ask Mr. Sneed to confirm.
Yes, Your Honor. From our understanding, Ms. McClure had a conversation with the complainant, and in this case, as well as the complainant in the misdemeanor downstairs. As such, the plea agreement would involve Ms. Schultz pleading to count 1 in this file as charged with agreement into a sentence in recovery court, and the plea will be set aside at the successful completion of recovery court. With that, dismissal of count 2 in this file, as well as dismissal of the district court file downstairs 251614. And along those lines, there is a no contact order right now. I don't believe it's on these files, but I believe it'll be down in district court. But either way, again, Ms. McClure had a discussion with the complaining witness, the victim in these matters, and she was fine with the lifting of the no contact with an entrance of the plea. So again, that's our complete understanding of the plea agreement.
Okay, Mr. Sneed, is that a complete and accurate statement of the plea agreement?
Yes, it is, Your Honor.
Okay, Ms. Schultz, will you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Monica Lynn Schultz?
Yes, Your Honor.
Ms. Schultz, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 1, larceny in the building?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 4 years in prison and or a $5,000 fine?
Yes, Your Honor.
Are you satisfied with Mr. Murphy in the advice that he's given?
Yes, Your Honor.
Neither the prosecutor, defense attorney, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we discussed it today. Is that correct, Mr. Murphy?
Yes, Your Honor.
Is that correct, Mr. Sneed?
Yes, Your Honor.
Is that also your understanding, Ms. Schultz?
Yes, Your Honor.
If a guilty plea is accepted, there'll be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those to you now to make sure that you understand. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to have the witnesses against you appear at your trial, and you or your lawyer could ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at the trial if you wanted to testify. You understand, Ms. Schultz, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
You also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right.
Yes, sir.
If you're not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of your rights?
No, yes, sir.
Do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead then to the charge that on or about June 27, 2025, in Raisin Township, Lenawee County, Michigan, you did commit the offense of larceny in a building?
Guilty.
Has anybody made any threats or promises to you to induce you to plead guilty to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that that plea was given as a result of threats or promises that were not disclosed to the court on the record today, or that it was not your own choice to enter the plea? I'm sorry. I just didn't hear your answer.
Oh, yes. Yes.
Yes, sir.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than plea bargain to induce Ms. Schultz to plead guilty today?
No, Your Honor.
No, Your Honor.
Ms. Schultz, other than as it's been discussed on the record today, has your attorney promised you any particular sentence or estimated what your sentence would be?
No.
Is it your own choice to plead guilty today?
Yes.
If your plea is accepted and you engage in misconduct, the court will not be bound by any sentencing agreement or evaluation. Misconduct includes, but is not limited to, absconding or failing to appear at sentencing, violating bond conditions, violating the terms of any plea or sentence agreement, or otherwise failing to comply with an order of the court pending sentencing. Do you understand that?
Yes, sir.
Is it your own choice to plead guilty today?
Yes, sir.
All right. Mr. Murphy, do you want to establish the factual basis?
Yes, Your Honor, thank you. Okay, Ms. Schultz, were you indeed in the city of Adrian, the county of Lenawee, the state of Michigan on June 27th of this year?
Yes, sir.
Okay, and were you at, what was it, 12 Ridgemont Drive.
Yes.
Is that a house?
Yes.
Okay. And while it was in the early morning hours around 6 or 7, did you take property from that house that wasn't yours?
Yes.
Was that your mom's property?
Yes, sir.
Okay, and did you then go and try to, did you go to a pawn shop afterwards?
Yes.
Would you agree that was your intent for some period of time to deprive her of the value of that property?
Yes.
Your Honor, I think we established a factual basis.
Sir Sneed, are the people satisfied?
Yes, thank you.
Okay. Has the court complied with MCR 6.302 B, C, and D, Mr. Sneed?
Yes, Your Honor, thank you.
Mr. Murphy?
It has, Your Honor, thank you.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Ms. Schultz has had full knowledge of her rights, and she has had competent counsel. Court has not made any agreement regarding the plea or sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation. And Ms. Teskey, if we go with November 14th, is that sufficient time to have a screening done?
Yes, Your Honor. I'll just need Matt to send a referral over for us because that's how we kind of get that started, but that's enough time.
Okay, so we'll set the sentencing for November 14th at 8:15 a.m.
Thank you, Your Honor.
Ms. Schultz, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay.
And if you will step across the hall to the probation department, they'll have a packet of information to give you before you go and give you some instructions on what happens next.
Thank you.
Okay.
Thank you, Your Honor.
All right, thank you. I think we're all set with this case then.
Thank you.
Your Honor, may I have that sentencing date again, please?
That was November 14th.
Okay, thank you.
Okay, so I think that is everything until the motion hearing at 10:30.
Thank you, Judge.
Your criminal docket's done, Your Honor, besides the Richard Adams.
Correct.
Okay, so I will be here if you need me on him, if he pleads guilty or whatever.
Okay,